You are welcome to yet another episode of HN What's Your Say? The #1 listening show where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. In attorney Jennifer Bonjean's New York appeal brief, she stated in one of her arguments that the government in fact failed to prove that defendant is guilty of forced labor charges in relation to Geronda Pace and Faith Rogers. Both claims based on one-time isolated sex acts that neither victims alleged were forced in any way. It is however alleged that R. Kelly did direct Geronda and Faith Rogers to perform intimate acts on him, where an isolated act is neither a form of labor or service, and neither of the said victims testified that they were in fact forced to do this. The government hereby failed to provide proof for violation of federal labor laws. In fact, according to Jennifer Bonjean, no rational juror would have come to a conclusion that the defendant knowingly obtained or agreed to obtain any form of labor or services from the accusers. And these charges are therefore yet another example of the government's transparent efforts to again stretch a statute far beyond its intended purpose to reach conduct that can no longer be reached by the state authorities. For a conviction of forced labor to apply, the government is required to prove beyond reasonable doubt that the defendant obtained the labor and services of another person, made threats of serious harm, and that the defendant acted knowingly. And additionally, the government must establish a causal link between the labor and services provided by the person and the threat of serious harm. While the forced labor statute does not define the words labor and service, the words take their ordinary meaning, which is expenditure of physical or mental effort especially when fatiguing, and service is defined as the performance of work commanded or paid for by another. Bonjean in her submission adds that according to Section 1589 intended to address serious trafficking of cases where traffickers threaten to harm third persons, restrain their victims without physical violence of injury, or threaten dire consequences by means other than overt violence. The harm considered from a vantage point of a reasonable person in the place of a victim must be sufficiently serious to compel a person to remain in her condition of servitude when one would have otherwise left. According to the government, the defendant R. Kelly in January of 2010 violated the forced labor statute by using threats of violence to obtain labor in form of acts of oral sex by Geronda Pace. Accepting the government's evidence at its best light, Geronda described a single isolated incident in which defendant allegedly assaulted her because she was angry and had disrespected him, and Geronda testified that after the assault, she sat with him in the VIP room where he instructed her to perform the act on him, when she adds that she complied. According to Bonjean's appeal brief submission, Geronda did not testify anywhere that defendant threatened her, forced her, or even harshly demanded that she give him the oral contact. Geronda also did not testify that she feared defendant would assault her again if she had chosen to decline the request. In fact, Geronda did not even testify that she did not want to offer the defendant the requested sexual contact, but what she says is that after the incident, she left defendant's place on her own free will. Accepting Geronda's account as true simply does not establish an act of forced labor. And also important to note, an isolated sexual act does not qualify as either forced labor or services, especially where there is no commercial aspect to the incident and where the alleged victim did not testify that they expected any form of terminal benefit from the act. Moreover, the testimony does not show that Geronda gave defendant this intimate contact out of fear or threats of violence, notwithstanding the prior assaultive behavior. It wouldn't have taken so much for Geronda to in fact make the casual link between the sexual act and her fear of physical assault by the defendant, but she simply didn't. Bonjean therefore concludes that the jury was not free to jump to such a conclusion in absence of Geronda's testimony, and particularly where this case was an isolated one. Similarly, no reasonable juror would have drawn the conclusion that defendant R. Kelly in fact knowingly obtained or agreed to obtain any labor or services from a Faith Rogers in January of 2018, who testified that she traveled to Los Angeles to see a man with whom she had been having a romantic relationship, and this one time found a gun in the room that allegedly intimidated her, but conceded that defendant never threatened her with it or made any gestures that he intended to use it. Faith was simply uncomfortable by its presence, she added in her revealing testimony. This is not enough for any reasonable juror to assume forced labor, and Faith herself refuses to identify as someone who was forced to do anything. On cross-examination, Faith further confesses that she was not a victim and had chosen to be with defendant. In her own words, she did say that I am not a victim, and let's be clear, I am a young woman who made a choice to be with that person, but I had a choice and that's why I walked away. Bonjean adds that the forced labor statute was never enacted to remedy such isolated sexual occurrences like the one described by Faith Rogers and Geronda Pace. And in fact, there is nowhere in her testimony where Faith Rogers states that she communicated to defendant she did not want to perform the act of oral contact on him. And she certainly did not end her relationship with defendant after this incident because she clearly wanted it. In fact, during the New York appeal hearing, an appeal judge did raise the concern that government was misusing the forced labor statute to cover incidences that are covered in the Racketeering Act 6, which bear virtually no resemblance to paradigmatic forced labor cases and their victims, which in a way abuses the statute. Now listen.
So I'm a little concerned about applying the forced labor statute in this context because it seems that you run the risk of really federalizing all kinds of state sexual assault and being able to turn it into federal offenses with much different consequences for the individuals. Can you address that concern?
Person did not perform that labor or services, the person or person would suffer serious harm or physical restraint.
So wouldn't that apply to any kind of rape prosecution?
So I don't think the court has to reach the outer boundaries of what the statute may or may not apply to in this case, because there was a clear pattern that was far beyond something like a one-time rape. So for the specific victims,
but in some cases we are talking about just one or two instances, right?
Well, I don't think so. So as to Geronda, what was charged was
So you think we should focus on the actions that constituted the force as opposed to the labor that was forced?
But the issue is the labor component, it seems to me. So what does the isolation have to do with labor? It might all be true, but where is their labor?
Well, I am just pointing the court to the other portion of Section 1589. Geronda, who was one of the victims of the forced labor charge, testified about how she had to write false letters. Faith also was forced to send a text message.
But is that the labor? So writing false letters is the labor?
No, the labor
I mean,
would
Raniere, these folks were doing other things. They were doing things for free, right? That would be easily described as labor. Some of it sexual, some of it not.
Well, again, I think that people pay money for work on websites, people pay money for transcribing tapes and reviewing articles, and people pay money for sex. So I think under the definition that this court has given in Raniere...
So I think that's where we're back again. And you keep saying we don't need to go to the outer boundary, but it seems to me your argument is any sex act, including a rape, is forced labor.
I believe that sexual activity does count under this court's definition of labor and service.
When asked where is the labor, the state attorney had no real answer to this question because there was no labor after all. All she was describing were isolated sex acts which simply do not qualify as forced labor and should be dropped by the appeal court. According to Mildred, by the time an appeal judge felt the need to ask the state attorney where is the forced labor, there is in fact need to be concerned because it meant he clearly didn't see it. In fact, the government has time and again misused statutes that are designed to achieve different objectives to address their selfish concerns, and for this reason, I will not be surprised to see R. Kelly win this appeal as many of these charges are dropped, including the forced labor charges. If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.